Next important question that arises with regard to preamble is it a part of the Constitution, and what do we mean by the basic structure? The word basic structure has not been defined in the Constitution. It is only through judicial pronouncements that we know what is basic structure and what is included in basic structure. The Supreme Court in Keshwananda Bharti versus State of Kerala 1973 overruled its earlier decision of Re-Beruberi case 1960 and made it clear that it is a part of the Constitution and is subject to the amending power of the Parliament as any other provision of the Constitution, provided the basic structure of the Constitution as found in the preamble does not get disturbed. Significance of the preamble. Constitution of India in its preamble reflects the basic structure and the spirit of the Constitution, though the word basic structure has not anywhere been used in the Constitution or in the preamble. It is regarded that the preamble serves as a channelizing tool for the interpretation of the Constitution as a whole. 2. Preamble acts as the preface to the Constitution of India and lays down the fundamental values and philosophical ideas. It represents the entire Constitution in written words. Next is another significant feature is that it contains the basic features of the Constitution and considered to be a vital part of it. It is significant because it highlights the type of society and the government it wishes to establish. However, we can say that it does not contain, the preamble does not contain the laws enforceable in a court, but no law can be enacted or amended in a manner that violates the spirit of the preamble. Thus, the preamble of the Constitution we can say is unamendable and unalterable. What is constitutionalism is another basic point in this lesson. First is that modern political thought draws a distinction between what is constitution and what is constitutionalism. The underlying difference between the two concepts is that a constitution ought not merely to confer powers on the various organs of this government, but also seeks to restrain those powers. Constitutionalism, on the other hand, envisages checks and balances and putting the powers of legislature and executive under some restraints and not making them uncontrolled and arbitrary. Unlimited powers, we all know, always jeopardize the freedom of the people. Constitutionalism, we can say, is the antithesis of arbitrary powers. The antithesis of constitutionalism is despotism and in essence connotes limited government or a limitation on government. Thus, we can say that a written constitution, independent judiciary with powers of judicial review, the doctrine of rule of law and separation of powers, free elections to the legislature, accountable and transparent democratic government, fundamental rights of the people, federalism and decentralization of power are some of the principles and norms which promote constitutionalism, a very important feature of our country. Coming to what is constitutional interpretation, the basic question here arises whether judges make law or they only declare the law already existent. As per the orthodox view that we followed for years together is that judges only declare what is given in the text, that is, they do not make law. Well-established rules of interpretation require that the meaning and intention of the framers of a constitution, be it parliament or a constituent assembly, must be ascertained from the language of that constitution itself. With the motives of those who formed it, the court has no concern. Then is the literal versus liberal approach. In the Re, C.P. Berar Act 1938, popularly known as the Central Provinces case. After quoting the observations of Lord Wright in James versus Commonwealth, that a constitution must not be construed in a narrow or pedantic manner, and that construction which is most beneficial to the widest possible amplitude of its powers must be adopted. It said that a broad and liberal spirit should inspire those whose duty is to interpret the Constitution, but it does not imply that they are free to stretch or to pervert the language of the enactment in the interest of any legal or constitutional authority, theory, or even for the purpose of supplying omissions or of correcting the supposed errors. Then the Pramati Educational and Cultural Trust versus Union of India is a famous authority on the case. In this recent case, which is popularly known as Pramati, on constitutional interpretation, the bench upheld the constitutional validity of the right of children to free and compulsory education, Act 2009, popularly known as RTE Act. This being a reaffirmation of the court's earlier decision that was pronounced in 2012 in the Society for Unaided Private Schools of Rajasthan versus the Union of India and others. The second part of this Pramati judgment exempts all minority institutions from the RTE. This is an expansion of the ambit of exemption from society case, which had limited it to unaided minority institutions only. Minority institutions here refer to both religious and linguistic minorities as referred to within the Constitution. Then the case of Aruna Roy versus Union of India on Article 28 Clause 1 of the Constitution came up for interpretation. As in the national curriculum prepared by the NCERT, study of religions was sought to be introduced in the state-aided institutions. Prohibition on religious instruction under Article 28 Clause 1 of the Constitution came up for consideration before the court. It was held the expression public religious instruction used in Article 28 Clause 1 has a restricted meaning. It conveys that the teachings of customs, practices relating to religion, rituals, and the ways of worship in educational institutions wholly maintained out of state funds is not allowed. But Article 28 Clause 1 cannot be read as prohibiting the study of different religions existing in India and outside India. If that prohibition is read with the words religious instruction, study of philosophy which is necessarily based on study of religions would be impermissible. That would amount to denying children a right to understand their own religion and also the religion of others with whom they are living in India and with whom they may like to live and interact. Study of religions, therefore, is not prohibited by the constitutional provisions, and in the Constitution, it should not be read so. We can say that a court of law, in other words, must gather the spirit of Constitution from the language used, and what one may believe to be the spirit of Constitution cannot prevail if it is not supported by the language, which therefore must be construed according to well-established rules of interpretation. Uninfluenced by an assumed spirit of the Constitution, where the Constitution has not limited, either in terms or by necessary implication, the journal powers conferred upon the legislature, the court cannot limit them upon any notion of the spirit of the Constitution. Since we know that Constitution is the supreme law, it lies upon the courts to determine the meaning and scope of the law or action. As interpreters or the arbiters of legal disputes, they have to tell what the law is. In doing so, We believe that they give due regard to the powers and autonomy of the other organs, particularly of the legislature, whose purpose is to make laws. The courts presume that the legislature acts are all constitutional unless proved otherwise. But the cases are not always clear, and therefore the cases are not always clear, and therefore an unending debate continues on the role of the courts in judging the validity of these laws, particularly of the Union Parliament. Next is that interpretation by courts becomes necessity for the protection of individual rights guaranteed by the Constitution for the growth of Constitution itself, and is like an institution protecting and upholding enduring values enshrined in the Constitution. The law creative function of the judges is well recognized now in the modern contemporary world. A judge has his own scale of values and makes choices according to that. If one interpretation of law leads to unjust results, as we have seen in the case of Aruna Roy, and another to just results, nothing prevents a court from adopting the later construction. This is the purposive rule of interpretation, that the Constitution is interpreted in such a manner which is a liberal, a purposive construction, a purposive interpretation to serve what for the Constitution and the preamble was framed. Not everything is explicitly given in the Constitution. By way of interpretation, the judges have been able to enlarge the preview of certain provisions of the Constitution, giving it the widest possible ambit. Then is influenced by these judicial attitudes, there have been two approaches. One is to the interpretation of written Constitution. One is the literal approach, which is a mechanical, narrower interpretation of the Constitution, where the judgment constitutes only about the text, the exegesis of the fundamental text, that is we call as the literal approach. The other, which is followed now, is the liberal, purposive, law creative interpretation of the Constitution, with the premise that the Constitution, being the fundamental law of the land, should be interpreted more liberally than an ordinary statute. Lastly, is the sum up of our discussion today is the need of the hour is to adopt an integrated approach in the interpretation of the Constitution in the light of social, economic, political necessities of a particular period in which the court is called upon to interpret. We have seen the features of the preamble. The preamble enshrines what the founding fathers of the nation had in view. The country must adopt that. The interpretation by courts should be such that makes the Constitution a workable law or an instrument by treating it as a dynamic living document which needs to be suitably interpreted to meet the exigencies of the modern world today. Thank you.